Field sobriety exercises. Reports state that Tony Romo participated in standardized field sobriety exercises and that officers believed he performed poorly. These roadside exercises may include the horizontal gaze nystagmus test, the walk and turn exercise, and the one-leg stand. The public sometimes hears that someone failed a field sobriety test and assumes that guilt has already been scientifically established. That is not necessarily true. Field sobriety exercises are investigative tools. Their reliability may depend on whether the officer gave the proper instructions, demonstrated the exercise correctly, used appropriate testing conditions, and accurately recorded the person's performance. The defense may examine the roadway surface, lighting, traffic conditions, weather, footwear, age, injuries, balance limitations, medical conditions, nervousness, and whether the officer interrupted or confused the person. The body camera footage becomes important because it allows a court, and eventually a jury if applicable, to compare the officer's description with what actually appears on video. Did the person truly lose balance? Did the officer explain the exercise correctly?
I'm going to make a couple of passes, okay? Top of my pen here.
So what am I doing? Just tell me,
Which,
am I looking at it or?
You're going to look at the top of my pen.
Okay.
Stimulus, okay?
So my eyes are going with it. Got it.
Yes.
Okay.
Make a couple passes here, okay?
Okay, so I'm following this as you move it. That's what you're saying?
Yes, sir.
Okay, got it. Am I supposed to move my head or am I supposed to keep it square?
Would you like the instructions one more time, sir?
I think I got you.
Okay.
Just trying to do it right. I'm sorry.
It's okay. Got to keep your head still, please.
Well, that's what I was asking. Okay.
Okay. So, eyes and eyes
just
only.
the eyes
Yep.
move only.
Hmm?
That's what I was asking. I got you. I'll move the head just a little to get there. Sorry. Got it. Are you waiting for me? Sorry.
Probable cause for arrest. Reasonable suspicion may justify an investigation, but arrest generally requires probable cause. Probable cause is not proof beyond a reasonable doubt. It does not require the officer to possess enough evidence to guarantee a conviction. It generally requires facts and circumstances that would lead a reasonable person to believe that an offense probably occurred and that the individual committed it. Police may attempt to establish probable cause through a combination of facts: the alleged traffic violation, driving behavior, statements made by the driver, an odor associated with alcohol, physical appearance, field sobriety performance, an open container, a preliminary breath test result, when one exists, and the officer's training and experience. The absence of swerving does not automatically eliminate probable cause. A person could violate another traffic law or appear normal while driving, but exhibit other signs after the stop. At the same time, police cannot simply collect a group of weak or innocent facts and automatically label them probable cause. The judge must examine the quality of the facts, not merely the number of allegations.
On the line, ahead of your left foot, with the heel of your right foot against the toe of the left foot. Exactly. Yep, exactly how I'm doing.
Okay.
Place your arms down at the side.
What am I doing after that?
Maintain this position until I complete the instructions.
Okay. What are the instructions after that?
So maintain that position for me. Would you like me to start over?
Well, I just want to see, what am I doing?
Okay, I'll start.
I was just asking.
So picture a straight line in front.
Yep.
Okay?
I got it.
Take your left foot, put it on that line.
What do I do after that?
Take your right foot,
Okay.
put it in front.
Okay.
Heel to toe touching. Place your arms down at the side. Maintain this position until I've completed the instructions.
Are
You
there
can-
any instructions after that or no?
Do not start to walk until you're told to do so.
Okay.
Do you understand the instructions so far?
So I put my left foot down, right foot in front on the line, and then I'm going to wait for you. Correct? Got it. I think I'll use not the accidental fall off of that. Okay. Ready?
When I tell you to start, take 9 heel to toe steps on the line, turn and take 9 heel to toe steps down the line.
Okay.
I'm going to demonstrate by doing 3 steps.
Okay.
Okay? When you turn, keep your front foot on the line and turn by taking a series of small steps with the other foot.
Okay.
I will demonstrate it for you, okay?
Yep.
While you are walking, keep your arms at your sides, watch your feet at all times, and count your steps out loud. Once you start walking, do not stop until you have completed the test. Do you understand the instructions?
No, I don't. There's too many. We got to go step by step.
Okay, all right. So, take your left foot,
Okay.
put it on the line, the straight line, real or
So
imaginary.
if you could show me how to do it real quick.
Take your right foot,
So left foot, put the right foot in front.
left foot on the line, right foot in front, heel to toe
Okay.
touching.
So right here,
Yep. Heel to toe touching.
here.
Yep, just like this. Left foot on the line, right foot directly in front of it, arms down at your side while she explains the rest of the instructions.
Got it. So
Okay.
stay here.
Yep.
Okay. Got it.
All right.
Now what am I doing?
Place your arms down at the sides. Okay? Keep your arms down at the side. Maintain this position until I have completed the instructions. Do not start to walk until you're told to do so.
Okay.
Do you understand the instructions so far?
I got it.
When I tell you to start, take 9 heel to toe steps on the line, turn, and take 9 heel to toe
What
steps.
does that mean by turn?
I will demonstrate for you, okay?
Got it.
When you turn, keep the front lead foot on the line
Sorry, 1 second.
and turn by taking a series of small steps with the other foot.
Yep.
I'm going to demonstrate with 3.
Yes, thank you.
You will do 9, okay?
Okay, sounds good.
Okay.
Just sitting in there. Sorry guys, 2 back
1,
surgeries. That's right.
2, 3.
Okay, so put it foot in front. Yeah.
I'm sorry?
Sorry, my bad. You go ahead. Keep
Okay.
going.
You're going to use a series of small steps.
Okay.
9 heel to toe steps.
You said 3 times? Or no?
Sorry, sir?
Did you say
Can you refuse the test? This is where many people misunderstand the process. A person may be asked to perform roadside exercises, provide a preliminary breath sample, submit to an evidentiary breath test, or provide blood or urine. These are not all legally identical. The rules vary by state, and refusing can create serious administrative or evidentiary consequences. A person may lose driving privileges. The refusal may be introduced as evidence under applicable law. Police may seek a search warrant. And refusing a test does not automatically make the entire OWI case disappear. But refusal can prevent the government from claiming that the person voluntarily consented to a particular search. That distinction matters. There is a difference between saying, "I voluntarily give you permission to search my body and take my blood," and saying, "I do not consent. Obtain legal authority if you believe you have probable cause." Refusing consent does not physically prevent police from applying for a warrant. It requires the government to justify the search before a neutral and detached magistrate, unless another recognized exception applies.
3 times? I'm sorry.
No. The next text is going to be the one leg stand.
Okay.
Okay? Please stand with your feet.
Normal life. Good.
Please stand with your feet together and your arms down at the side. I'm demonstrating it for you.
Yep. Show them how to do it.
Do not start the test until I tell you to do so. Do you understand?
Yep.
Okay. Would you like me to read the first part over
I would
again,
like
sir?
you to show. Thank you.
Please stand with your feet together, arms down at the side. Do not start the test until I tell you to do so. Do you understand?
I do.
When I tell you to start, raise either leg
Okay.
with the foot approximately 6 inches off the ground, keeping your foot parallel to the ground.
Like this.
Keep both legs straight and your arms down at the side.
Here.
So foot parallel to the ground, okay?
Like that.
All right, keep both legs straight and your arms down at the side. Holding that position, count out loud in the following manner.
Okay.
1001,
Okay.
1002, 1003, and so on until you are told to stop. Keep your arms at your sides at all time
Okay.
and keep watching the raised foot.
Okay.
I'm going to demonstrate for you, okay?
Okay.
And then you just tell me which foot you want to raise, okay? I think I'm going to raise my right,
Yeah.
okay? Approximately 6 inches, 1001, 1002, 1003, 1004, and so on until I tell you to stop,
You got it.
okay? Gotta tell you to begin.
Not bad. Can't do that. Yeah. Can't use that actually. Yep. I got you.
Right.
The blood draw cases. In 2013, the United States Supreme Court decided Missouri versus McNeely. Justice Sonia Sotomayor authored the principal opinion. The government argued that because alcohol naturally disappears from the bloodstream, every suspected drunk driving case involved an emergency, allowing police to draw blood without first obtaining a warrant. The Supreme Court rejected that automatic rule. The natural dissipation of alcohol does not, by itself, create an emergency in every case. Courts must examine the specific circumstances. Could police reasonably obtain a warrant? Was there an accident requiring urgent attention? Were officers occupied with injured people? Was the suspect being rushed into emergency medical treatment? Was there some genuine circumstance making the warrant process impractical? In an ordinary investigation, where officers have enough time to seek judicial approval, the Fourth Amendment generally requires a warrant before a non-consensual blood draw. Then came Birchfield versus North Dakota. In that case, the Supreme Court distinguished breath testing from blood testing. A breath test is less physically intrusive and reveals a more limited category of information. A blood draw pierces the skin, removes part of the person's body, and may preserve biological information beyond blood alcohol concentration. The court held that a warrantless breath test may generally be allowed as a...
What must be presented to the magistrate? When a person refuses a blood draw and police seek a warrant, an officer ordinarily submits an affidavit to a magistrate. The affidavit should describe the facts supporting probable cause. The officer might describe the driving conduct, roadside observations, statements, field sobriety exercises, the presence of alcohol, and other evidence. The magistrate does not determine guilt. The magistrate determines whether the affidavit establishes a fair probability that evidence of the suspected offense will be found through the requested search. This is an important constitutional checkpoint.
When does a Fourth Amendment violation occur? A Fourth Amendment violation could potentially occur at several points. The original traffic stop may have lacked reasonable suspicion. The officer may have unlawfully prolonged the stop. The OWI investigation may have been expanded without adequate justification. The arrest may have lacked probable cause. A warrant affidavit may have lacked sufficient facts. The affidavit may have contained material falsehoods or reckless omissions. police may have conducted a warrantless blood draw without consent or genuine exigent circumstances. But no single fact automatically decides every one of those questions. The absence of swerving does not automatically prove that the stop was illegal. The refusal of testing does not automatically defeat the prosecution. And the issuance of a warrant does not automatically establish guilt. Each link must be examined separately.
The exclusionary rule. When evidence is obtained through a Fourth Amendment violation, the defense may file a motion to suppress. Suppression means asking the court to prevent the government from using illegally obtained evidence. Suppose the court finds that the original stop was unlawful. The defense may argue that the field sobriety evidence, statements, arrest, warrant application, and chemical test evidence all resulted from that unlawful stop. This is commonly described as the fruit of the poisonous tree. However, suppression is not automatic in every case. Courts may consider doctrines such as attenuation, independent source, inevitable discovery, and good faith reliance. That is why the legal analysis must follow the complete chain. Was the stop lawful? Was the investigation lawfully extended? Was there probable cause to arrest? Was there probable cause for the warrant? Was the warrant executed properly? And was any exception to the warrant requirement genuinely applicable?
The lesson from the Tony Romo case is not that wealthy people possess special constitutional rights. The Constitution applies to everyone. The practical difference is often access to information, counsel, investigators, experts, and the resources necessary to challenge the government's evidence. A person who understands the process may know that refusing consent is different from physically resisting an officer. They may understand that asserting a constitutional right is not the same as obstructing justice. They may know that police can still seek a warrant. They may know that refusal may bring separate consequences. And they may know that the government must justify each step of the process. The public should also understand that refusing a test is not a magic formula for escaping an OWI or DWI case. Police may possess enough other evidence to establish probable cause. They may obtain a warrant. They may use body camera footage, witness testimony, driving behavior, statements, open containers, and field sobriety evidence. The real constitutional question is not simply, did the person refuse? The question is, after the refusal, did the government follow the Constitution? Did police possess sufficient facts? Did they present those facts honestly? Did a neutral magistrate authorize the search? Or did officers bypass the warrant requirement without a legitimate emergency? That is the legal process. Not assumptions, not celebrity status, not public opinion, and not guilt by headline. The process requires evidence. The process requires constitutional authority. And the process requires the government to justify every intrusion, from the moment the vehicle is stopped to the moment evidence is offered in court. Tony Romo is entitled to that process. So,
The accused. Under Wisconsin's implied consent law, I'm required to read this notice to you. You've either been arrested for an offense that involves driving or operating a motor vehicle after using alcohol or drugs or both, or you are suspected of driving or being on duty time with respect to a commercial motor vehicle after using alcohol or drugs or both. This law enforcement agency now wants to test one or more samples of your breath, blood, or urine to determine the concentration of alcohol or drugs in your system. If any test shows more alcohol in your system than the law permits while driving or a detectable amount of a restricted controlled substance, your operating privilege will be suspended. If you refuse any requested test, your operating privilege will be revoked and you will be subject to other penalties. The test results or the fact that you refuse testing can be used against you in court. If you take all the requested tests, you may also choose to take the alternative test that this law enforcement agency provides free of charge.
What is that?
You may also...
What's the alternative?
You may also have a test conducted by a qualified person of your choice at your expense.
Oh.
You, however,
I'll do that.
will have to make your own arrangements for that test. If
Okay.
you have a commercial driver's license or were operating a commercial motor vehicle, other consequences may result
Yeah.
from positive test results or from refusing testing, such as being placed out of service or disqualified.
Okay.
Will you submit to an evidentiary chemical test of your breath?
No. Like I said, I want my lawyer
Okay.
for the 8th time.
This is Second to None Media, where we examine the evidence, study the procedure, and ask the questions that must be answered before anyone is judged guilty. Remember, an arrest begins the legal process. It does not end it. And before you go, stay with us for the closing music, featuring Chris Cooley, an independent artist whose music helps bring our productions to life. If you enjoy the music, show Chris Cooley some love by supporting his work, streaming his catalog, and following his journey. Independent artists thrive because of listeners like you, and every stream, follow, and share helps keep great music alive. From all of us at Second to None Media, thank you for watching. We'll see you in the next video.
Is your computer running slower than it used to? Maybe it's freezing, showing strange pop-up messages, or refusing to connect to your printer or Wi-Fi. Technology problems can be frustrating, especially when they interrupt your work or everyday life. Instead of spending hours searching for answers online or trying random fixes, professional technical support may be able to help. You may need a support company that provides assistance for many common computer and technology issues that help users like yourself to troubleshoot problems they need with PCs, Macs, software, internet connections, printers, and other devices. If you're looking for more information about the service and want to see if it's right for your situation, simply call the phone number on your screen. That number is 1-833-652-6124. Don't let computer problems slow you down. Call 1-833-652-6124 now to learn more.